What if I am injured by a hazard created by the owner of a store? Hi, my name is David R. Price Jr. and I'm a personal injury trial attorney in Greenville, South Carolina. I dedicate my practice to helping injured people, and I want to share some valuable information with you. When a person is injured at a premises owned by another person, lawyers often refer to these types of cases as slip and fall cases or trip and fall cases. This references the mechanism of injury, where a visitor to the premises often slips in a slick spot or trips in a hole or some other hazard located on the premises. This is a complicated area of law, and liability of the owner often rests on whether the owner had actual knowledge of the hazard or whether the hazard had existed so long that he knew or should have known of it. This is known as constructive notice. An example of this can happen at the grocery store. If a customer of the store slips on a grape that's fallen on the floor, the store owner will only be liable if the injured person can show that the store owner knew about the grape or that the grape had sat there for so long that it had an opportunity to know of it if it had simply performed a reasonable investigation. Another subset of cases, in these slip and fall and trip and fall cases, occurs when the owner actually created the hazard. In that instance, where the owner actually created the hazard, he will be deemed to have notice of it so long as it's something that he reasonably should have known could have resulted in injury. A classic example is when an owner builds stairs that are not built to code. If a person trips and falls on uneven risers, the owner and person who built the stairs may be liable for those injuries. Examples that have occurred in my practice include a situation where a person fell and was injured on stairs after they'd been pressure washed by the owner, and a person who fell in an department store when she tripped on the foot of dress racks that were placed too close together with dresses covering the bottom. In that instance, because the store owner placed the dress racks much closer than it should have according to its own policies and procedures, the jury found that the store owner had created the hazard and found it liable for the injuries caused to two ladies who tripped over the racks. My name is David R. Price Jr. and I handle these kinds of cases every day. If you've injured yourself on a premises owned by another person, then I want to help you. Please call me at 864-271-2636 or visit my website at greenvillelegal.com. I'll give you the dedicated personal representation that you deserve.